Hello, in this session I will be discussing the legal dimensions of judicial review of administrative action. To keep the administrative machinery within legal bounds and prevent abuse of power, the courts have power to review any administrative action. The objectives of the session are to understand the concept of judicial review, study the grounds for judicial review and appreciate the constitutional basis of judicial review of administrative action. Judicial review means review by courts of administrative action with a view to ensure their legality. It is a power of Supreme Court and High Courts to review statutes and governmental actions to determine whether they conform to rules and principles laid down in the Constitution, which is the supreme law of the land. Any action by the government that violates the principles of Constitution is invalid. Broadly speaking, judicial review in India comprises of three aspects: judicial review of legislative action, judicial review of judicial decisions and judicial review of administrative actions. The underlying object of judicial review is to ensure that the authority does not abuse its power and individual receives just and fair treatment, and not to ensure that authority reaches a conclusion which is correct in the eyes of law. Judicial review is the most potent weapon in the hands of judiciary for the maintenance of rule of law. This is one of the checks and balances in separation of powers. The judicial review is basic and essential feature of the Indian Constitution. The process of review has a number of objectives. First and foremost, to uphold the principles of supremacy of the Constitution. Secondly, to maintain federal equilibrium, that is a balance between the center and the state. And finally, to protect the fundamental rights of the citizens. The range of judicial review recognized in India by the superior judiciary is perhaps the widest and most extensive. Besides review of legislation and administrative action, the power extends to examining the validity of even an amendment to the Constitution. For now, it has been repeatedly held that no constitutional amendment can be sustained which violates the basic structure of the Constitution. Review is different from appeal. In appeal, the appellate authority can go into merits of the decision of the authority appealed against. The review is supervisory rather than corrective in nature. It is concerned with reviewing not the merits of the decision or an order, but how the decision has been arrived at. Court's function is restricted to ensuring that such authority does not act in excess of its power. The court is not supposed to substitute its decision for that of administrative authority as long as the authority acts within the ambit of power given under the statute. No court should interfere. Generally, judicial review of any administrative action can be exercised on four grounds. First, illegality. If decision maker fails to follow law properly, the decision, action or failure to act will be illegal. The second is irrationality. Courts may quash a decision if they consider it to be so unreasonable as to constitute irrationality on the part of decision maker. The third ground is procedural impropriety or fairness. This principle applies solely to the matters of procedure, like the rules of natural justice must be applied by the deciding authority. The fourth ground is proportionality. Administrative authority maintain a proper balance between the adverse effects which the legislation or the administrative order may have on the rights, liberties or interests of the person, keeping in mind the purpose for which they were intended to serve. On judicial review of policy decision, it is well settled legal proposition that the policy decision taken by the state or its authorities is beyond the purview of judicial review, unless the same is found to be arbitrary, unreasonable or in contravention of the statutory provisions or violates the rights of individual guaranteed under the statute. However, the policy decision cannot be in contravention of the statutory provisions if the legislature provides for a particular right, guarantee, benefit. The authority taking a policy decision cannot nullify the same. Now let us see the constitution basis for judicial review. The Constitution in India explicitly establishes doctrine of judicial review in several articles such as Article 13, 32, 131 to 136, 143, 226 and 246. Article 13 specifically declares that any law which contravenes any of the provisions of the part of fundamental rights shall be void. The Supreme Court and High Courts are constituted as the protector and guarantor of fundamental rights. Under Article 32 and 226, they have the power to declare any law or administrative action which transgresses a fundamental right as void. Judicial review is an integral part of our constitutional system. It is the basic structure of the Constitution. The right to move the Supreme Court itself is a fundamental right. It is not only the right and power, but the duty of the Supreme Court to protect the fundamental rights of an individual. Article 32 can be invoked only for the violation of fundamental rights, whereas under Article 226, High Courts can issue writs not only for the enforcement of fundamental rights, but also for any other purpose. The remedies available to an individual against an illegal administrative action include writs, special appeal, injunction, declaration, suit for damages for tortious acts and breach of contract can also be granted by Supreme Court and High Courts. Under Article 32 and 226, Supreme Court and High Courts have power to issue writs which include the first, habeas corpus, which is a writ issued by the court to bring before the court a person from illegal custody. The court will examine the legality of detention and release the person if detention is found illegal. The second is mandamus, which is issued to a public authority to do an act which under the law it is obliged to do or to forbear from doing something. The third writ is prohibition. High Court has the power to issue an order of prohibition to the executive authority prohibiting it from acting without jurisdiction. The fourth writ issued is certiorari, which is issued to a judicial or a quasi-judicial authority to correct its order. The fifth writ which is issued is quo warranto, which is issued to a person who unauthorizedly occupies a public office to step down from that office. High Courts and Supreme Courts have a power to issue not only these writs but also appropriate directions and orders as suited in a particular situation. Recently, there is a rising trend in judicial activism in India. The doors of the judiciary are kept open for redressing the grievances of persons who cannot ordinarily have access to justice. In such cases, if a public spirited person comes forward on their behalf, courts relax the rules and adjudicate over the matter. In the matter of socially and economically backward groups or persons who are not aware of their rights or not capable of pursuing their case in the court, the complex and rigorous procedure formalities are not insisted upon. Therefore, with the power of judicial review, the courts act as a custodian of the fundamental rights. So, with this, I come to the end of discussion on judicial review and leave you with few questions which you will find easy. Thank you for watching this video.